Hello and welcome to this Field Seymour Parks webinar on updates and developments in employment law. Essentially, we're going to be taking you through everything that you need to know for 2018. My name's Ian McRae and I head up the employment law team here at Field Seymour Parks. Now, essentially, we have split this webinar into 4 sections. We're going to start off with looking at some recent holiday pay decisions, an area that continues to develop. We're then going to look at worker status and how that is distinguished from self-employed contractors and some risks there for employers. We'll then look at the general data protection regulations, which are due into force in May of this year and will affect all businesses. And then finally, we're going to look at monitoring your employees at work, so keeping an eye on their email and what you can and can't do there. Some changes to taxation of termination payments and some other miscellaneous provisions you need to be aware of in 2018. So let's move on and have a look at holiday pay. And essentially, to begin with, what we're going to do is recap the position, in particular pre-2014, which is when a number of these decisions started to come out. So essentially, at that point in time, 2 basic distinguishing types of holiday pay. One was for employees with no normal working hours. And essentially for them, you calculated their holiday pay on the basis of what they'd done in the previous 12 weeks before they were off work. It's the second category that we're really concerned with. And this is the employees who have normal working hours. So maybe they work 40 hours a week, they take their annual salary. And previously, particularly before 2014, the way most employers would approach that is that those employees only got their basic salary when they were away on holiday. So any overtime, commission and similar payments that they might normally have received if they'd been at work were disregarded. And that's the area that's been repeatedly challenged, and that's what we're going to be looking at here. So I'm going to recap very briefly some of the previous cases. So we had the case of Williams and British Airways, which essentially said that contractual allowances should be taken into account when calculating holiday pay. We then had the high-profile case of Bear Scotland, which was to do with non-guaranteed overtime. So by that I mean overtime which the employee is required to do, but the employer is not required to offer. And in what they said in that Bear Scotland case was, again, that class of payment needs to be taken into account when calculating holiday pay. And the other one I'll mention is the Lock and British Gas case, which concerned contractual results-based commission. So your classic type sort of sales commission. And with all these cases, the underlying point is the courts and tribunals are concerned that if you only pay basic salary when people are on holiday, and in reality they earn much more when they are at work, there's going to be a deterrent. They're not going to want to take the holiday pay because they're not going to be paid the same as they would do if they were at work. So what I want to move on to is a different class of work and of payment, which is to do with voluntary overtime. And I want to discuss the case of Dudley and Willett, which is again from the summer of 2017. So in that case, the employee worked set hours, but they also worked additional hours at their discretion. So essentially they were voluntarily working additional hours which they were paid for. They brought an unlawful deductions from wages claim, stating that their holiday pay should have taken into account the overtime, the voluntary overtime, which they would have earned or were likely to have earned had they been at work. The council, maybe somewhat unsurprisingly, disputed that and said that because there was no intrinsic link between the payment and the performance of the tasks, it was different from the Bear Scotland case. It was different from the Lock case. These aren't contractual payments. This is voluntary overtime. And that was the distinction they tried to make. Now, the Employment Tribunal disagreed with the council and said that those voluntary overtime payments should be taken into account when they were regularly worked. So this case then proceeds to the Employment Appeal Tribunal, to the EAT. And the EAT upheld the tribunal decision. They agree with the tribunal. And what they said is that if there is an intrinsic link between performance and pay, then that is decisive. Then it should be taken into account. But it's not the only determining factor. It doesn't automatically follow that because the employee was not contractually obliged to do this extra work, that these payments shouldn't be taken into account. And what they said is that it can still constitute normal remuneration and therefore should be taken into account when working out what people should be paid when on holiday, if it's paid on a regular and recurring basis and over a significant period of time. So even if it's voluntary, if it complies with those tests, then it needs to be taken into account. Unfortunately, there wasn't much, or indeed very little, guidance on what that actually means. What is regular? What is recurring? What is a significant period of time? And what the Employment Appeal Tribunal has said that that is a question of fact that has to be determined from case to case. But the key underlying point of this is this idea of deterrent. You don't want a holiday pay system that is going to deter your employees from exercising their European-derived right to holiday. And if you do have a system that is paying them substantially less than they would be if they were normally at work, then that's something you're certainly going to need to look at. The second holiday pay decision I want to look at is the case of King and Sash Window Workshop. Now, for the sake of explaining this case, I've got to go back and look a little bit of the underlying law to give it a little bit of context. So the first thing to realise is that under the Working Time Directive, which is European derived, each worker is entitled to at least 4 weeks paid annual leave a year. The UK implemented that by passing the Working Time Regulations in 1998. But what the Working Time Regulations did is they split that right into two. They said there is a right to leave and there is also a right to be paid for that leave. And the enforcement of those rights is is separate. So you can bring a claim if you've been denied the time off, you've not been allowed your holiday, or you can bring a claim because you've taken the holiday but you've not been paid for it. Now what that gives you a little bit of difficulty with is where there's a situation where the employee has not taken their holiday, but they haven't been denied it, they haven't made the request for it. And that's the situation that was looked at in this King and Sash Window Workshop case. So the facts of this case, Mr. King was a commission-only salesman. He'd worked for the company for 13 years and he was treated as self-employed. So he didn't get any salary, no payment for holiday or sickness absence. And essentially when his contract was terminated, when he hit 65, which is another issue which we won't talk about today, he sought to claim that he was a worker and therefore had been entitled to holiday over these previous 13 years. And he brought a case before the Employment Tribunal. The tribunal found that he was a worker, he was entitled to holiday and awarded him 3 different things. The first thing was holiday pay for the current holiday year. So the holiday that he'd accrued but not taken in that year leading up to the termination. Quite straightforward. Second one was for previous years where he'd requested holiday and taken it but not been paid for it. Again, reasonably straightforward. But it's this third category that caused the problems. The tribunal also awarded him a sum of money for the holiday that had accrued in previous years but which he'd not taken and he'd not tried to take. And this final element, the issue of whether or not he should receive a payment for that, was appealed up to the Court of Appeal and then on to the European Court of Justice. Now, what did the European Court of Justice make of this? Well, the first thing they said is exactly what I mentioned earlier on, which is this separation of the right to leave and the right to pay suggests that the only remedy for employees in this situation is to take their holiday and then bring a claim once they're not paid for it. And they, in short, said that's not compatible with the European directive. If a worker is unsure they're not going to be paid, they're not going to benefit from relaxation and leisure, which is part of the purpose of the European directive, and again, they're going to be deterred from taking holiday. Would you take holiday if you know you're not going to be paid for it? Well, maybe not. And what they also said, it was irrelevant that the employer in this case thought that Mr. King was self-employed and not a worker. And it was also irrelevant he hadn't put in any requests for leave. There were no preconditions to that right to paid holiday. The final point is the key point really, which is what they said is the directive requires the carryover of paid holiday rights until termination of that employment. And that's the issues that's caused a lot of concerns. So if we look at that in a little bit more detail, it potentially suggests that workers and employees can bring claims for decades of unpaid holiday, especially if their status has been misclassified. So Mr. King was treated as self-employed, so he wasn't given a right to holiday. And essentially this decision potentially allows him to claim relatively large sums of back payments of holiday. There is also the point that you can't cause a break in this. So even if Mr. King had been offered paid holiday in the interim, the liability still remains until termination. So it continues to roll on despite the fact that the issue might have been resolved. Now, the case has been returned to the Court of Appeal, mainly to decide whether or not the UK legislation, the working time regulations, can be interpreted in line with European law. There's a couple of other questions that arise from this, which is in the Bear Scotland case, there was a suggestion that a sort of a 3-month period in which you got paid holiday correctly broke a series of deductions and therefore meant that historic claims were less likely. And also the deduction from wages regulations, again, tried to place a 2-year limit on these sort of historic holiday pay claims. And there's been a suggestion from some commentators that those decisions, that law is unlawful or is bad law in light of this decision. I think what you have to be aware of is that this case has dealt with a specific situation where Mr. King was wrongly considered self-employed, and it was a situation where he had not tried to take leave, and therefore it may well be distinguished from other cases. So what do you need to be doing in light of these two decisions? Well, firstly, you need to make sure you have identified all of your workers and your employees, and you're not treating someone as self-employed when they're not. You need to understand the payments that are being made out, including how regularly and what it may constitute. So you need to understand the commission that's going out, the overtime that's going out, the allowances and bonuses that are being paid. Because until you understand that, you won't know whether or not those payments fall within these different classes of decisions that mean you should be taking those payments into account when working out holiday pay. The other thing is to see whether or not you think your holiday pay system could act as a deterrent. So if you're not paying sufficient money when people are off on leave, could they be deterred from taking holiday? If so, you need to look at it quite closely. You may need to adjust your payment calculations if you don't think they're lawful. You equally may want to adjust your working arrangements. Do you want to restrict overtime more? Do you want to place some further limits on it? Do you need to change your commission structure? They might be all things you need to consider. And then you need to be careful about how you present that change. So what you're not going to want to do is present it in such a way as that almost omits sort of past liability for previous holiday years. And then finally, updating your contracts of employment to reflect what you've done will be important. So a few final points. Usual caveat with this webinar, very brief introductory summary. Please do take your own legal advice on specific circumstances. We will be publishing updates on all of these areas as part of our free email updates. If you'd like to receive them, please just email me and get in touch with any questions, feedback or suggestions you might have for these webinars. My details are on this slide. And if you haven't already seen them, this is part 1 of 4 parts of this session. Worker status, general data protection regulations and some other changes due in 2018 are covered in the other elements.